Hey patent friends, welcome back to another video. So you're looking to hire a patent attorney and you found somebody that you want to reach out to. In this video, I'm going to tell you all the tips and tricks to start your relationship off with a patent attorney right, so you make sure you get good quality patent service, top quality patent assets, and don't shoot yourself in the foot from the very beginning. And be sure to watch to the end because I'm going to give you the insider stuff that a lot of people don't realize when hiring a patent attorney that causes huge problems from the get-go. So stick around, we are starting right now. So for those of you who are new here, my name is Dylan Adams. I'm a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit, with Marcus Lemonis. So this channel is all about giving you the insider tips and tricks about patents and navigating the patent system and working with patent attorneys. So if you're looking for more content like that, be sure to subscribe to the channel and hit that little bell icon so you don't miss any great new content coming out. All right, let's go ahead and get right into it. So to understand the optimal way to reach out to a patent attorney, it helps to understand what patent attorneys actually do day to day. So the first thing to understand is that patent attorneys are typically really busy folks. So for me, as an example, I have a yearly billable hour requirement, and it ends up being that I have to bill about 7.5 hours per day. And that's just billable hours. That is actually working with clients doing substantive patent work. That doesn't include doing things like bills. It doesn't include just general meetings, and it doesn't include new business development, that being receiving queries from people potentially wanting to work with me. So assume that the patent attorney you're going to reach out to is really busy. And that's why I typically don't recommend giving somebody a call. I don't think the phone is the best way to contact somebody, because you're probably not going to be able to catch them immediately. Usually it's going to go to voicemail, and then it's sort of awkward because you say, well, hey, give me a call back at this number, and there's not usually a great time to do that. The better way, as I'll just kind of discuss later on in the video, is it's better to schedule a specific time to talk to a patent attorney so they have time to understand what's going on with you and prepare for the meeting, instead of it being sort of an impromptu thing where you call somebody up and expect to get an initial consultation out of that. Similarly, you really don't want to just show up at somebody's office. A lot of times, especially these days, patent attorneys aren't going to be working in an office, and if they are, it's very unlikely that they're going to be available at a specific given time. So my suggestion is to start with an email contact. So if email is the best way to make an initial contact with a patent attorney, what should be in this email? So the first thing should be how you found them as a patent attorney. So for instance, if they were referred to you by somebody, that's a really important thing to put in there, because then they're going to be a lot more likely to be responsive to you, than somebody who's just a random cold call. Let them know, hey, I found you online, or I watched your YouTube videos, I saw a talk that you did, things like that. Make it personal. Try to distinguish yourself in the sense that, hey, I'm not just randomly spamming people. I specifically found you, I looked at your background, and I think that you're a good fit. Another thing you want to do is have a basic bio of yourself, your company, and your invention. Okay, so you don't want to have it be too long, but you want to give somebody the basic flavor of what's going on. Who are you? What sort of company do you have? What sort of technology do you have? And as I'll discuss later on, you'll want to give them more detail at some point, but keep it pretty brief in the beginning. Just something basic. Say, hey, I'm an early stage startup. I have done a seed round of funding, or I am an inventor. I'm self-funded. I'm at early stages, and let the patent attorney know kind of what you're looking to do. For instance, say, hey, I'm looking to file a provisional patent application, or I want initial consultation. I want to know about the patent process. Let them know kind of generally what you're looking for. Along with that is you want to let them know what times you're available to schedule a time to discuss. And I would say, propose sometimes, maybe that week or maybe the following week, but generally, let the patent attorney know what your availability is so that you can schedule something. You don't want to have a conversation over email ideally. A good way to start a relationship is do a phone call or do a video call. That tends to be the best way to start off this relationship. So things not to do, like I said, keep it really short in the beginning. You may be tempted to have a long description of, hey, here's my company and here's why it's so much better than everything else out out there, and here's my whole life story, and here's what my company has been doing. I mean, you will get there, and I'll tell you how to provide that information. But in the beginning, keep it really short, just so people understand generally who you are and kind of a flavor of what's going on. But don't make it too long, and don't make it too intrusive with too much. Another thing is, don't ask your attorney don't ask the patent attorney to sign an NDA. So anything you talk with, even at initial stages, is going to be protected by attorney-client privilege. The patent attorney is required to keep everything you talk about confidential. So don't do something like asking for a non-disclosure agreement. A lot of patent attorneys are not going to be allowed to. It's a liability issue. Like, for instance, my firm, I'm not allowed to sign non-disclosure agreements. The client confidentiality of the attorney-client privilege, that is sufficient. So I'm not even allowed to sign those things. But honestly, a lot of attorneys are going to find it off-putting if you ask them to sign an NDA. So don't do something like that. So you've drafted and sent off this email, and then what do you do next? So the first thing is understand that, again, patent attorneys are really busy. You may not hear back for 24 hours, maybe more. So don't necessarily expect a quick reply. A lot of times that's the benefit of email, is that it can be asynchronous, and you can give the patent attorney time to fit it into their schedule to give you a reply. So don't be upset if you don't hear back quickly. So at some point you'll probably hear back. Patent attorney is going to say, hey, sounds good. Here's my availabilities. Let's schedule a time to discuss. And then work to sort of schedule the time to meet with them. Usually half an hour is pretty standard, unless it's an in-person meeting. That'll maybe be more like an hour. But a lot of times an initial patent consultation really doesn't need to be more than a half an hour. A lot of times, if you're going over half an hour, you're probably giving too much information. I'll kind of get into that next. So one thing you may consider is, when you're scheduling this meeting and when you're sort of setting up the meeting, is to provide the patent attorney with more information about your invention and about your company. Now, the first thing is, like, don't put stuff in the body of the email. Don't require the patent attorney to read a bunch of stuff. A lot of times that can be seen as kind of intrusive and a little much. So what I would suggest is, again, keep it relatively short in the body of the email, but if you happen to have documents, say like a pitch deck or information about the invention, put that in there in an attachment. I mean, for me, honestly, I can't help myself. I want to read those things. I'll go over it. And it really benefits you to put that in there and do it in a way that seems like, hey, this is optional. You don't have to look at this, but just for your reference, in case you're interested, here are some materials. Like, for me, I like reading those things, and I'll read through everything. And by doing that, you're going to get a lot of free advice and a lot of free context, instead of just, say, like, presenting those materials in the meeting and then having somebody sort of do sort of a cold read of that without any background and time to really digest it. I mean, for me, I'll look at things a day or two in advance, and I'll think about it. I'll be thinking about the invention and the company and advice that I want to give and things for several days. So I would suggest give that information up front, and you're going to get a far better initial consultation if you give more information instead of less. So the day for your meeting has come. So how are you going to want to conduct this meeting? The first thing is, you should be completely open about your invention and your business. You're going to get a far better initial consultation if you're completely transparent of things. Again, you're going to be covered by attorney-client privilege, so the attorney must keep things confidential, isn't going to disclose things to anybody else, and most importantly, is not going to steal your idea. Patent attorneys, it makes no sense for them to steal ideas. They make their money off of patenting things, not stealing ideas or not creating business of their own. There's too much on the line for patent attorneys to steal ideas. So you're going to be far better off if you're fully open about the idea. Talk about it in as much detail as the attorney wants to talk about it. Don't hold anything back. And again, don't ask them to sign a non-disclosure agreement. So in this initial consultation, you should probably be able to get a lot of information out of the patent attorney and really get some good advice. So for instance, ask about things like patentability. Ask the attorney, well, now that you know about my invention, do you think it's patentable? Do you think that there's going to be any issues with patentability that you can see? Ask about things like, when should I file a patent application? What sort of patent application should I file? Should I file a provisional or a non-provisional application? Should I do a prior art search before filing a patent application? And you'll probably know from a lot of my videos, I do not recommend prior art searches, but there are some cases where doing a prior art search does make sense. So ask about those sort of things as well. You can get a pretty comprehensive sense of patentability just from a small consultation, and get pretty much a game plan as far as a patent strategy that is tailored to your business. So talk about those sort of things. Talk about where you are with the business, where you are with funding, what your steps are in the next few weeks, in the next few months, in the next few years. Really kind of talk about the business plan, because tailoring a patent strategy really depends on those things. And if you're working with a good patent attorney, they're going to want to know those sort of things. It's not a one size fits all sort of deal. It depends on your business plan. Are you looking to license the idea? Are you looking to build the product yourself and sell the product? Or is it a startup where you need to attract investors? The way you build a patent portfolio and the timing of it is going to be very different based on the specific product and based on the specific business plan that you have. So definitely talk about those things. Also, you're going to want to talk about what your plans are for making public disclosures, public uses, or offers for sale, because that's when patent rights start to be forfeited if you don't file a patent application. So patent rights start to be automatically lost in pretty much all foreign jurisdictions upon a first public disclosure, public use, or offer for sale. And in the US, you have 1 year after those occur to file a patent application. Otherwise, you forfeit your rights. And while you may not be thinking about foreign patent rights being important at early stages, realize that there may be some partners or investors that you may be approaching who find foreign protection to be really important. So the best thing to do is to file a patent application before you make any public disclosures, public uses, or offers for sale. And that's why you'll want to tell your patent attorney about any plans to do that, because that's really going to dictate when you're going to want to file a patent application. Similarly, if you're going to start approaching investors, that's another thing that your patent attorney will want to know. And while talking to investors, typically, unless it's something public, say like Kickstarter or things like that, you're not going to be forfeiting patent rights, but your pitch is going to be a lot better if you can go in and say you're patent pending. You don't have to worry about NDAs, and then they know that, hey, you have something protected. You have some actual assets around these ideas and things. So you want to talk to your patent attorney about, hey, what am I thinking about approaching investors, and that's going to also dictate when you're going to want to file patent applications. Now, once you've talked about everything and asked all your questions, and hopefully you've come prepared with questions, probably it would be good to create a list of questions that you want answered, or at least topics that you want to go over, and check those off. Make sure that you get the most out of this initial consultation. So you're going to go through all that initial consultation stuff, and then talk about next steps. What is the next thing that you're going to do to move the relationship forward if you want to do so. If you're not sure about it, say, hey, let me get back to you. Or, if you are interested, say, hey, what are the next steps that we want to do? Typically, it's going to be a few things. One is for pretty much all attorneys, they're going to have to do a conflict check to make sure that they don't represent anybody who has similar technology or somebody who is conflicting in other ways. So, for instance, if you have a law firm that represents somebody in litigation against your company, you probably won't be able to represent them in patent matters as well. So, if it's a solo practitioner, they're probably going to know right off that there are no conflicts. So they know about all the patent matters that they have. Whereas large firms, like for instance my firm, we have close to 40 patent attorneys and agents and other folks, and there's a lot going on. I'm not aware of everything that's going on a regular basis, and that's just in the patent group. We have over 600 attorneys, and we don't, I don't necessarily know who is being sued by who's representing who, and things like that. So we have to do a more formal conflict check, and that's going to be part of getting you set up as a client. You have to pass that initial conflict check. You may have to pay an initial retainer or an initial deposit. Usually what you're going to be doing is not really a retainer. A retainer truly is where you pay a lump sum and then the attorney does all legal work for you based on that retainer, and maybe follow-up retainers. Usually when people think of a retainer, or at least in the patent sense, it's going to be more of an initial deposit where the patent attorney will say, hey, this is how much I think the project is going to be, and I will bill against that initial deposit. Some people will call it a retainer or an initial deposit, but typically it tends to be about the same. And then you'll get set up as a new client, and the attorney will send you an engagement letter which will formalize your relationship. And that's going to be really important because that is when you actually have an attorney relationship and when it's solidified. Otherwise, don't assume that you're being represented by that attorney. So when it comes to that initial meeting, what do you not want to do? So like I said before, you don't want to be cagey about what your invention is or what your business is. Be open with your patent attorney. One, they're covered by the attorney-client privilege. Anything you say is going to be held in confidence. They can't disclose that to other people. Okay, and don't ask for an NDA. Don't be worried that they're going to steal your idea. You're going to get a lot more value out of this initial consultation if you're completely open and transparent about things. Also, don't treat it like an investor pitch. You're not trying to sell the patent attorney on your business to become an investor. You may want to do some things that that's kind of like a pitch, but a lot of times it's kind of wasteful for people to go through a pitch deck and do sort of a formal sort of pitch meeting like they would do to investors. A lot of times it's not quite the information that I'm looking for, and it's not the best use of your time. You want to give some basics about your company and about the invention and let the patent attorney ask questions about it, but I wouldn't recommend doing some sort of formal pitch or things like that. That's not the best use of your time. And another general thing, and especially when starting off your relationship with a patent attorney, is don't insist on specific things. And this is a bit counterintuitive that you probably have done research, you probably have a sense of what you want to do, but don't go into things, don't go into the relationship saying, hey, I want to file a provisional application, I want to do it right now, or I want to file a non-provisional, I want to do a prior search, I need to do an infringement analysis, things like that. Because a lot of attorneys, they're just going to say, okay, sure, if that's what you want, I'll do it for you. They're not going to think critically about it and actually ask, well, are you sure you really need these things? A lot of folks maybe just want to upsell you and will do stuff even if it's needless. Go into things saying, hey, if you have done research, say, hey, here are my thoughts. I was thinking about filing a provisional application. Here's my thoughts on that. What do you think? What are your suggestions? Your patent attorney should really be a close confidant in a lot of ways. This is somebody who's really gonna, make a major impact on your business and help structure your patent portfolio. They really know those things. And so, you may have a general idea of what you want to do, but be open to different things. And I see people kind of kick themselves in the foot a lot of times where they go and say, I want this, and the patent attorney, sometimes they're kind of intimidated and they're like, well, okay, I'm not going to fight you on it. If that's what you really want, I'll do it. I'll take your money, but it doesn't make sense. One of those things is filing patent applications too early. People make, especially startups, they make that mistake all the time, and they're wasting their money and wasting their time and creating a lot more risk for their business. So for instance, they say, well, hey, we're in a first to file system. You get priority based on when you file. I want to file my provisional application immediately. And that's really a mistake. A lot of times you're not really going to have a full sense of what the invention is until you've done all the research, you've created prototypes, until you're really ready to start doing pitches. And so what I typically say is wait to file a patent application until when you're actually ready to make public disclosures, public uses, or offers for sale, or when you're about to approach investors. Don't insist on filing too early, because you file, for instance, your provisional application, it lasts for 12 months. That 12 months goes by really fast. That provisional application will then expire. Then you have to file the expensive non-provisional and spend a ton of your own money on this really expensive non-provisional, when really you should be getting traction with investors, with partners, with sales, things like that. So the longer you can delay those costs, the better. That's why it's better to file your patent application later. Also with startups, a lot of people will go in and say, well, I'm ready for a non-provisional application. Why would I do a provisional application? And that's just not a great idea typically. Especially for startups and early stage companies, you want to maintain flexibility and keep costs low. Provisional applications are great for that. First, they can be done really informally. You can file really anything as a provisional application. It doesn't have the formal filing requirements that the non-provisional does. But more importantly, it gives you a lot of flexibility. So like I said, the provisional application, it's just a placeholder. It only lasts for 1 year. It expires at the end of that year. And then you have to file that non-provisional application, which is the expensive one, that claims priority to the provisional. So what you can do a lot of times is, you're going to be at one stage of the development of your product when you file that provisional. And again, hopefully that's when you're about to make public disclosures, public use, or offers for sale, or approach investors. But there's going to be a lot of R&D that goes on within that year that the provisional is pending after you file it. And then at the non-provisional stage, you can add things that you've come up with over that year. So doing the provisional and non-provisional allows you to incrementally protect the invention and the technology. If you just file the non-provisional, you can't really incrementally protect it without having to file a completely new non-provisional. It's not very cost effective. So those are some things that you want to keep in mind when you're doing this initial consultation and just when engaging a patent attorney in general. So if you got some value out of this video, please give it a thumbs up and check out these videos right here. Some great content as well. And thanks for watching. We will see you again in the next video.